at any time necessary. I welcome everyone to today's hearing on oversight of the Voting Rights Act, potential legislative reforms. Before we continue, I'd like to remind all the members that we have established an email address that we have previously shared and we previously reminded you about with a distribution list to circulate exhibits or other written material the members may desire to offer as part of our hearing today. I also ask unanimous consent that our Judiciary Committee colleagues, Representatives Madeline Dean and Mary Gay Scanlon, be permitted to join the panel in the limited capacity where they will be allowed to ask questions if yielded time by a member of the subcommittee. Without objection, thank you. Finally, I would ask all members and witnesses to mute your microphones so when you're not speaking. This will help prevent feedback and other technical issues, and you, of course, may unmute yourself anytime you seek recognition. I'll now recognize myself for an opening statement. Throughout his heroic life, our former colleague and friend, the late, great John Lewis, often said the right to vote is the most powerful nonviolent tool we have in a democracy. If we are ever to actualize the true meaning of equality, effective means such as the Voting Rights Act are still a necessary requirement of that democracy. Last month, we marked the one-year anniversary of his death. Let us not allow another anniversary to go by without ensuring the enactment of the legislation that bears his name, the John R. Lewis Voting Rights Act, to see that we carry forth with what his life's goal was, which was voting. He gave blood when he started the Selma to Montgomery March, almost killed, risked his life. Others did lose their lives in fighting for the right to vote. Just south of here in Mississippi, I'm in Memphis, Schwerner, Cheney, and Goodman were killed in Philadelphia, Mississippi, simply trying to register people to vote. This problem, which has existed since my childhood, when I was in Memphis, where there were segregated drinking fountains and days to go to the zoo and days to go to public events, and where all public facilities had color-only sections. And let me tell you, I noticed those were not the good seats. They were the worst seats in the football, the basketball, the theater, you name it. Vestiges of those days still haunt us. And that's why this is such an important bill, because they percolate up so many times in voting. This subcommittee has devoted considerable time and resources in taking up John Lewis's call to defend that right to vote. All of us in Congress must rededicate ourselves to protecting this most fundamental right at a time when it is once again under severe threat. The record we have built over the course of 13 hearings in the last 2 years is crystal clear. Voting discrimination against citizens based on race, color, or language minority status is a current and worsening problem that Congress must address through a renewed and strengthened Voting Rights Act. The tidal wave of voter suppression that the nation currently faces comes as no surprise. It is entirely predictable result of the Supreme Court's 2013 decision known as Shelby County, as in Alabama, versus Holder, which effectively gutted the Voting Rights Act's most important enforcement mechanism, Section 5, the preclearance provision. It struck that formula that determined which jurisdictions were to be subject to the preclearance requirement. Most of those jurisdictions were in the Old South, where discrimination led us to a civil war, led us to Jim Crow, and still haunt us. Under Section 5, states with a history of voting discrimination were required to obtain approval from the Justice Department for any changes to voting rules prior to their taking effect, therefore giving probable cause or a prima facie case when certain actions in the past had shown there was reason to be suspect, and the Justice Department could show the need to protect citizens. In striking down that coverage formula, the court held that in order to justify states unequally, those that had been listed in the Voting Rights Act and those that hadn't, Congress must create a formula based on current needs. The court invited Congress to develop a new coverage formula, which is part of our mission today. In the absence of preclearance, states and localities have been implementing measures to further deny or abridge citizens' right to vote on account of race, color, or language minority status. And all after one of the most free and fair and impartial and elections in our country's history, the most looked at and reviewed. Just since the 2020 election, several states have proposed or enacted restrictive voting laws in the name, as they call it, of election integrity protection. at a time when we just had the most circumscribed election ever, analyzed and unanimously said to be free and fair and accurate. Not surprisingly, those states include some of those that have previously been subject to the VRA's preclearance requirement because of their history of voting discrimination. According to the Brennan Center for Justice, as of July 14 of this year, 18 states have enacted 30 laws that restrict the right to vote, including measures that target mail-in and absentee voting. And let me just remind everybody that 5 states in our country have mail-in voting for every voter in all their elections. And it started back in Oregon over 2 decades ago. But they've targeted mail-in voting and absentee voting and increasing the risk of faulty voter purges and imposed stricter voter ID requirements. We're not going to go into some of the laws that discuss giving powers to state legislative groups to overrule election commissions, because that's just an overall abridgment of voting rights and not necessarily based on race or speech or color. That's simply politics. At a minimum, these measures disproportionately impact racial and language minority citizens in ways that could result in those citizens being denied the right to vote. Just last month, the Texas legislature began a special session to pass a new omnibus voting measure that would restrict voting access by creating new ID requirements for voting by mail and clamp down on new voting rules instituted by Harris County, the home of Houston, Texas, the state's most populous county and its most populous city, and one of its most diverse regions. Those laws in Harris County were designed to increase voter access. The Texas Senate passed its version of its bill just 4 days ago. In the absence of preclearance, plaintiffs have been forced to rely on litigation under Section 2 of the Voting Rights Act, which applies nationwide and prohibits voting rules that results in the denial or abridgment of the right to vote based on race, color, or language minority status, to confront these challenges. Yet the Supreme Court, in its recent decision, just July 1, a little over a month ago, in Brnovich versus the Democratic National Committee, significantly curtailed the ability of plaintiffs to succeed in claims alleging vote denial under Section 2 and burdening yet another of the Act's important enforcement tools. In the face of this sustained onslaught against voting rights by the states and localities and the erosion of the Voting Rights Act by the Supreme Court, Congress must act, and we have the power to do so. Our authority to stop race discrimination voting remains expansive, even in the terms of the Shelby County decision and the Brnovich decisions. The 14th and 15th Amendments to the Constitution, 2 of the 3 Civil War amendments, give Congress explicit legislative power to enforce voting rights and equal protection against purposeful race discrimination. So by acting, we are doing what the Constitution, in its most far-sighted fashion after the Civil War, said we needed to do to make us a more perfect union. Those amendments form the basis of Congress's authority to pass the Voting Rights Act in the first place. When the Voting Rights Act was first challenged just a year after its enactment, after Everett Dirksen and Republicans had the higher percentage of people voting for voting rights than Democrats, the Supreme Court in South Carolina versus Katzenbach upheld the preclearance provision and its coverage formula, holding that congressional authority to enforce the 15th Amendment was broad and comprehensive, and that implementing legislation needed only to be plainly adapted to a legitimate end. This rationality test is highly deferential to Congress, and notably, Shelby County did not disturb this essential hold. I also note that the Elections Clause, which confers ultimate authority on Congress to regulate the time, place, or manner of congressional elections, further bolsters Congress's constitutional authority to protect voting rights in federal elections, our elections. Congress's broad power under this clause does not implicate the federalism concerns expressed by the court in Shelby County. It is important that any new voting rights legislation include a new geographic coverage formula that responds to the court's concerns in Shelby County. We're charged to do that. It should also include a legislative response to the Brnovich decision and other measures, such as a practice-based coverage formula, reforms to the available scope of enforcement actions under the Voting Rights Act, greater notice and transparency requirements, and expanded authority for bail-in preclearance and the use of federal election observers. I thank Attorney General for Civil Rights Kristen Clark and all of our witnesses on the second panel for being here today and eagerly await their testimony. Ms. Clark will be our first panel.